We're going to quickly move on because we're running a little bit behind now. So we've got Yogi next, which is the best name ever, by the way. Yogi is a solicitor and the national head of the public law department for Irwin Mitchell. Yogi, it's like a ninja. Yogi.
What are you doing here? Are you there? There we are. We're there. Thank you, and thank you for inviting me to speak this afternoon. I'm hopefully for the next 25 minutes or so just going to whiz through a few cases in the Court of Protection. I seem to have fudged into the title of this section a further question, which is, are the guiding principles in the Mental Health Act featuring in Court of Protection case law? And when I came to prepare, I thought, why have I done that? There are obviously two different pieces of legislation here. We are operating under the Mental Capacity Act in the Court of Protection, and where the Mental Health Act operates, we try and stay away from it. So, anyway, there I have. I've looked at the guiding principles of the Mental Health Act, and so then I'm asking myself, well, is there a real overlap? Is there a real duplication of work, or are we actually operating in tandem and appropriately? So, guiding principles of the Mental Health Act, I remind myself, least restrictive option and maximising independence, empowerment and involvement, respect and dignity, purpose and effectiveness, efficiency and equity. They're your 5 overarching guiding principles under the Mental Health Act. So we then go to the Mental Capacity Act, and of course we've got our own statutory principles there, which focus on helping people make their own decisions, making sure that people have the right to make unwise decisions, making sure that those who lack capacity, what's done is done in their best interests, and the least restrictive principle. I've then drawn myself to think about the third important piece of legislation we're dealing with for adults with mental health difficulties, the Care Act, which came in last year. And again, you've got clear guiding principles under the Care Act, with a duty to promote well-being, preventing needs for care and support, integration of care and support with health, information advice, diversity and quality of services. So if I just put them all together and then ask myself, when we're in the Court of Protection and we're looking at adults who potentially lack capacity, asking ourselves, do they or don't they lack capacity on a particular issue, or where there's a dispute over that individual's best interest, where they lack capacity, is all of this helping guide some of the decision-making there? And we'll come back to that question as we look through some of the cases. A couple of other points before I just touch on the cases. First is, I'm very pleased that here in Manchester, we're up north, we've got people from all over the country, but I'm not here talking about cases that all operate and are being handed down by judges in the south and in London. I'm able to, thankfully, given the regionalisation of this court, you've got local judges, you've got judges sitting in Anglesey and Hull and all sorts of far-flung places, and those judges are very regularly, daily, dealing with Court of Protection cases. So there's a real body of evidence, body of knowledge in those cases. And thankfully today we're able to talk about some of the cases that actually were handed down by judges in the regions, not in London. Some of the most interesting and important cases, in fact, have come from out in the regions. A case I'm not going to talk about today, but was worth people going away and reading, I think, is a case called AB, handed down by His Honour Judge Rogers over in Lincoln County Court, all about how individuals should be involved in Court of Protection process how to approach the question of whether those individuals give evidence in their own cases. So that's the case unhelpfully named A local authority versus AB and others. His Honour Judge Rogers in Lincoln. But we will look at a couple of cases, and when we look at a survey of cases, we're also looking at themes. In previous years, there's been those seismic cases, Cheshire West and others, where there's a real shift and an impact on policy, impact on resources, etc. So this year, I think, is a bit more of a calmer year in my view. So we'll look at, have been cases where practice and procedure in the court of protection has been looked at, and we're not going to dwell on those today. Deprivation of liberty continues to be occupying the court, but not in the way that Cheshire West has. But we'll look at a case called SRK today. There's a case called MN, which we'll touch upon, and that looks at the question of what is the jurisdiction of the Court of Protection, where is the line before the administrative court is brought in to say the Court of Protection cannot go any further because of resources. Is it a public law issue? There are cases looking at the detail of the care plan and the care provision, which is as it should be in the Court of Protection. You're in there looking at the real detail of the least restrictive option, the placements, contact with family, sexual relations, all those issues that interesting issues and the court grapple with. And then we've had a couple of cases in the last year dealing with end of life, very important case of Rien, so we'll touch on that as well. Patients with a persistent disorder of consciousness, that's PDOC. So I'll start with SRK. So we were told last year in Cheshire West that we all in this crowd, I think, know what the test is for deprivation of liberty. What was left was the question of packages of people with care being delivered at home. And this was a case where a severely injured young man, injured in a road traffic accident, lacked capacity to make decisions in relation to care, residence, and treatment. So if you apply the Cheshire West test, objectively, subjectively, he lacked capacity and it was a deprivation of liberty. The individual had a substantial damages award, so that was there managed by his deputy, and there was a regime of care at home delivered by private carers, family and a private case manager. So I know those of you working in the community will see this as rare cases. There aren't that many cases where there are such highly privately funded packages out there, but there are a significant amount. And statutory safeguarding obligations still bite on those individual cases. They're often called private-funded, private care cases. Some people argue that some social workers kind of put that at the bottom of their pile because you've got private packages on board. But I think the important thing people constantly inform me to come back to is they're no less important. We've all I've certainly come across packages of care where family or deputies may have been managing a ward, but the individual may have been left in the corner of a care home for years, without proper review, without provision. Or in the community, there may well be some form of abuse, maybe involving family or others. So all of those cases continue to deserve the light being shone on them just as much as any other publicly funded case. So the conclusion in this case, I'll give it away even before we've gone into it, is that there was state imputability. The real question for the court in this case was, is it a deprivation of liberty? Objectively, subjectively it was. was this package, this private package, imputable to the state? What have the state got to do with it when the family and the private carers have put it in place? The Secretary of State was brought into this case, and they argued that there was no state imputability, there was no need for deprivation of liberty authorisation from the court, which is as it would be for a package at home. How he'd found himself in this situation. Sorry, just explain there on the slide what his circumstances are. 24-hour care at home, 7 days a week, limited communication and constantly monitored and supported by carers, private carers. Everybody in the case agreed that the package was in his best interests. The real question was it a deprivation of liberty, and did an authorisation need to be put in place? The answer was from Mr. Justice Charles that yes, an authorisation did need to be put in place, and if it wasn't, that there would be a breach of the positive obligations under Article 5 of the Convention. The cost of doing it all needs to be factored into the damages claim, which is obviously arranged and sorted out before a personal injury claim is settled. That was in the judgment. And why? Why do we need to do this when the local authority is once removed? And I think the answer is knowledge. What the court believed was, as the court, the civil court, authorising the award, knew the circumstances, as the court appointed a deputy, they knew the circumstances, they report to the Court of Protection. They then have to inform a local authority of the deprivation of liberty circumstances on the ground. They need to inform them that there is constant supervision and control. And as a result, the local authority's safeguarding duties kick in. Their positive obligations kick in, and they, the local authority, need to determine whether to put this deprivation of liberty circumstances on the ground at an end somehow, or whether they need to get an authorisation from the court. In this particular case, the deputy from Irwin Mitchell able to notify the local authority made the application, and the court authorised the deprivation of liberty. I think why the case is important is it's not an extension of the law, it's more of a clarification that in these private care packages, court authorisation is needed for packages of care at home. Practically on the ground, arrangements can be altered so it becomes less restrictive. And I think the other thing to really note from this case was the strong opposition from the Secretary of State. So this case comes up for a hearing in the Court of Appeal in a few weeks' time. But obviously we'll be arguing to maintain the status quo. So not an extension of the law, but gone are the days where we're thinking, because it's a private package, it doesn't need to be addressed by the court. It is imputable to the state, and they do. So that was the case of SRK. The next case we'll look at is Rio. Now, my notes actually say I can't say anything about this. I can't say anything about this because... can't say much about this because Mr. Justice Baker, whilst he handed down the judgment in open court and made clear what his judgment was, he actually hasn't handed down the full judgment, which means we're not really able to say what he said. It's all a bit odd. I did chase this week for the judgment, and I just kept getting told that it's still being amended. So it's been a number of weeks. Please look out for this judgment. It's all relevant to all of the people that deal with court of protection cases, deal with standard authorisations. It concerns the role of an RPR and an IMHPA and when cases should be brought before the court. You know the case of AJ from last year. This is the further case in which the judge looked at a range of cases for RPRs and IMCAs, Mr. Justice Baker asked himself in what circumstances should RPRs and IMCAs bring a challenge? What should they be looking for? Should they be asking the question whether the RPR's got a wider role? And what should they be asking the individual in terms of, should I bring the case to court? It is going to be rather controversial, I think, because it really moves on the question of, should you be asking an individual, do you want to go to court? Do you want to appeal the objections that they're raising? The case also looks at what the guidance should be about objections. What are the helpful factors about determining an objection? So, not very helpful, sorry, but look out for it. It's a judgment that will come out in the next few days, I think. The next case is AG, which is, I think, illuminating. It's a judgment from Miss District Judge Bellamy in Sheffield. And it's all about whether or not AG, who was a 92-year-old resident of a care home, we all knew she lacked capacity. In the Section 21A appeal, it's a prime example of the light being shone on a case, where the appeal was brought. The papers were then disclosed. The papers revealed that there was covert medication being provided. Not something that was evident on the care plan, not something that was evident on any of the standard authorisation papers, and quite a lot of people weren't aware that covert medication was being provided. So it's quite a rare case where covert medication has been talked about and what the rules are around providing it. So the judge very helpfully sets out the guidance to be provided on how to provide covert medication and how to make best interest decisions. The judge made clear that medication without consent are all aspects of supervision and control, and they're relevant to the question of deprivation of liberty. The decision about whether covert medication is provided needs to be proportionate and in the individual's best interests. Without consent, there needs to be close scrutiny, there needs to be policies in place, full consultation with professionals and family. In this particular case, it was said that social workers and family were not consulted. There wasn't a properly documented best interest meeting before the medication was provided. If there's a change in medication, the judge referred to the NICE, National Institute of Clinical Excellence guidance, confirming that the medication should not be administered covertly until after a best interest decision meeting is held, unless it's in urgent circumstances, that the care home needs to notify the supervisory body of the need for medication and of any change in medication to trigger a review. I think it's just a timely reminder for us all in terms of covert medication, because obviously professionals, people at the care homes, trying to control individuals and ensure that their care is in a busy care home, in a busy ward, that they're properly supervised and controlled. The question is that been properly documented? Has it been properly thought about whether that covert medication is too restrictive and overbearing? Final case. So I certainly do commend you reading the case, because it certainly goes chapter and verse into how to approach covert medication in cases of individuals in the community in care homes. Final case to talk about, and a very important case in medical treatment terms dealt with by the court. It's, again, in the long line of end-of-life cases, withdrawal of artificial nutrition and hydration. And this was a case of Mrs. N, 68-year-old, again from the Manchester area, who had multiple sclerosis. And the real question was, should there be a withdrawal of artificial nutrition and hydration? She was in a minimally conscious state. There was some debate about whether it was a persistent vegetative case or minimally conscious. That debate continued all the way to the final hearing. There was expert evidence provided to the court. But we're talking about an individual who was unable to communicate her wishes, but there was a strong body of evidence about what she would have wanted if she was in this situation. A strong body of evidence about how she viewed autonomy, because clearly that's the debate being raged in the Court of Protection, autonomy versus dignity. And a few years ago in W&M, the case fell down on the case of autonomy. It was dignity that the court focused on, and right to life. Well, since then there's been a case of Aintree in the Supreme Court, and now we've had this judgment from Mr. Justice Hayden in the case of N, where it's much more focused in the Court of Protection now on the wishes of the individual and what the individual would have wanted. Much less paternalistic in the approach of the Court of Protection. What Mr. Justice Hayden concluded in this case was where wishes, views and feelings of the individual can be ascertained with reasonable confidence, they're always had to be afforded the greatest respect, but rarely, if ever, determinative of best interests. To take a different approach, to say that the court knows best, essentially may result in indirect discrimination. The court needs to avoid paternalistic approach to ensure that individuals who lack capacity achieve equality with those who have capacity. There was really powerful evidence given by the family in the case about what the individual lady would have wanted, how she lived her life with autonomy, strong views on autonomy and how she lived her life and her wishes and feelings. That persuaded the official solicitor who acted for the individual to change their minds and support the application. They came to court opposing the application to withdraw treatment. After hearing the evidence of the family, they changed their minds and supported the application. So in light of the family evidence, the judge said he was left in very little doubt that Mrs. N would have been appalled to contemplate the early pain, dependency, remorselessness, degeneration that's now characterised her life in a minimally conscious state, and he's got no difficulty in accepting the family view that she would not have wished to continue as she is. She would have wished to have discontinued treatment. And then he talked about dignity and how to balance that in the balance sheet. The judge also talked about the Royal College of Physicians' guidance on the subject, because in all of these cases we see before the court, the problem always comes from the clinical team often not looking at the Royal College of Physicians guidance and seeing how to assess, diagnose and manage the patients to the conclusion in terms of making an application to the court. That is what really causes a major dispute, what causes the Daily Mail and the Telegraph to get quite upset about these cases and to rage the debate about right to life or right to end life. So he implores on clinicians to look at the guidance and to get a proper diagnosis and proper evidence to bring these cases before the court. I think what I take away from the shift in these cases, though, in the last year is that there are many more patients out there that can now bring their cases before this court. In this class of patients, every one of these patients who are in a minimally conscious state or persistent vegetative state should have continuing healthcare funding. Every one of these patients should have a dole's authorisation. That's all written into the Royal College guidance and accepted by the courts, so there's no excuse for those cases not coming before the court and having proper scrutiny. So, medical treatment cases, certainly full and frontal. I mentioned MN earlier. For those that don't know it, this is the case all about the scope of the court protection's jurisdiction, and where you have limited scarce resources, does the court probe and try and persuade for better packages? Do we have that gold-plated package some people misconceive that the court can award? And this case makes it pretty plain. We've had a judgment in the Court of Appeal which reiterates the law and says there is a line which the court protection cannot cross. The court can only rule upon available options, and local authorities and CCGs and mental health trusts can all say, we can't afford that package. That is all perfectly plausible and possible. And the court can't apply inappropriate pressure on public bodies. That's the state of the current law. It gets heard in the Supreme Court in the middle of December, in which Neil will go up against Alex Rutkeen and see if they can fight it out. I, for myself, hope that we continue to receive the current clarity, which is we accept there's scarce resources, but the court can rigorously probe and try and get good packages of care for individuals. So I'll leave it there. Thank you.
Thank you.